The County Council's latest round of revisions to the rural element update includes some significant changes from the city's perspective, and those changes and the city's concerns are outlined in its written comments. Many of these revisions were never reviewed or considered by the Whatcom County Planning Commission. The county released these revisions to the public on Monday, and I can appreciate that the county is under a deadline. But with the public hearing coming 2 days later, that is insufficient time for the public and the city of Bellingham to comment substantively in detail on the proposed revisions. There are three areas that I want to touch on real quickly in my remaining time. One is the designation of the Chuckanut area as a LAMERD. The city is concerned about this change as the LAMERD would provide for a density of 1 dwelling unit per acre. Such a designation is inappropriate for this environmentally sensitive area that lacks the necessary water and sewer service to support additional development at such densities. And such development will also have a significant negative impact on the city's transportation network in the south part of Bellingham. I've submitted, and I was going to go into detail, but given the limited time, I've submitted information including the city's ordinance showing that since March of 2006, we do not provide water to new development going down the Chuckanut. Governor's Point has never been included in that service zone, which was repealed in 2006, and we recently obtained a favorable ruling on summary judgment in favor of the city after we were sued by Governor's Point Development Company. The Governor's Point Development and their proposed subdivision is not going to be served by city water. And the court decision is also included in the city materials as far as the summary judgment finding in favor of the city on all major issues in that case. So it's important to emphasize with regard to Chuckanut, the city is not providing water for
30 seconds,
additional
please.
development. And secondly, there is no sewer, so you're allowing development of 1 acre parcels without water, adequate water. There are issues of adequate well water there, and without any provision for sewer. The other two comments I would have is we're concerned about the revisions that appear to decrease the protection for Lake Whatcom, and that has to do with the overlay district, overlay zone that Commissioner Crawford was actually the staff person was describing, and also the use of the LAMERD designations and the broad use of those LAMERD designations to allow non-rural character and development.
Tonight, I'm just going to be entering into the record a petition that we circulated in the last 35 hours, and I'll read it real quickly. As a citizen of Whatcom County, it's important to me that we think about long-term sustainability. I want to see our county prevent inefficient, inappropriate sprawl development that will be costly to taxpayers, degrade our rural character, and negatively impact our quality of life. Please ensure the rural element update adequately protects Whatcom County's farmers from residential encroachment, waters from runoff and pollution, taxpayers from additional costs, rural character that we all know and love. Specifically, please make sure the update does not allow 1 to 2 acre lots that are out of the scale and character of rural Whatcom County. And I'll turn in 7 copies here. And we do have further comments, so I would request that you keep the written record open as long as possible. Only 48 hours, we weren't able to get all of our specific comments together, and we have comments on some of the logical outer boundaries, some of the residential overlay zones, building sizes, Governor's Point, Lake Whatcom, and more. So thank you very much.
I'd like to speak first of early and continuous public participation. It's been over 15 months now since the Planning Commission recommendation, and this is the first public hearing that the County Council has held on its significant revisions to the rural element. Now, someone's going to say that there have been many, many work sessions during committee meetings and that many attending parties have been invited to speak. There are 2 flaws with this assertion. First, those meetings are not public hearings to which the public is invited in order to participate. They're not noticed as public hearings, the council isn't required to hear testimony, and the council doesn't have policies in place to ensure that all audience members are treated equally, as it does for this hearing. So those in the know are aware that the council likely will invite them to speak, and that makes them almost worse than public hearings because they function as private hearings. Second, the meetings are held during the day. That's not a problem if you're someone who makes your living from land development, but it makes it impossible for most members of the interested public to attend. And of course, the timing of this public hearing makes it pretty clear that the council might not be all that interested in public input. The public literally has had 48 hours in which to view the council's full proposal, which wasn't made available until Monday afternoon. That's not sufficient, and here's the proof. There is no staff report, probably because staff didn't have time. There's no draft ordinance or findings. There's no comparison of the changes made to the Planning Commission recommendation and no explanation of the changes made. If staff and the prosecuting attorney, whose day job this is, didn't have time to put together this information, imagine the burden on the public. So this is an open and continuous public participation. There's another hearing coming up, scheduled for the day of the deadline to complete the revision of the rural element. Before the next meeting, I would say please provide the public with sufficient time to review the proposal and supporting documents. And that needs to include the findings as well, because it is important for the public to know what information the council relies on in order to approve this rural element. For tonight, because information has not been provided in a timely fashion, I can only make general comments on the substance of the proposal. One striking change is that you stripped the comprehensive plan of every statement that described rural character as understood by the residents of Whatcom County. In fact, in revising the rural element, you're creating a pattern of rural development that violates rural character. Some of your landmarks appear to be too large, too close together, and to have irregular boundaries.
30 seconds,
They create
please.
strip development. You're failing to protect drinking water in Lake Whatcom by providing for the creation of small lots. You're failing to protect agriculture by providing for increased and inadequately buffered development. And you're failing to protect floodplains and water quality. This is our chance. This is our chance to decide what kind of place Whatcom County is going to be for the next generations. And we really need to treat this special place carefully.
I advocate a different approach to the rural element update than what has been proposed. Council looked at where growth currently exists and maintained and in some cases expands the status quo, perpetuating inappropriately cited development. Current science establishes that a comprehensive, watershed-based ecosystem model for rural development best protects public health and safety while promoting economic viability in the future. At a minimum, this requires reconciling proposed landmarks and density overlay zones to shellfish protection districts, critical areas, impaired water bodies, habitat conservation areas, resource land, and other areas entitled to special protection under local and state law. If development already exists in an area of high conservation value, such as Lake Whatcom, Drayton Harbor, or Lake Samish, no increased density should be permitted. Instead, this is an area that should be downzoned. Existing structures, lots, and uses should be allowed to continue under the county's non-conforming statutes so that the needs of the community are balanced with the rights of property owners while ensuring that past planning mistakes are not continued unrestricted into the future. Information necessary to plan under a comprehensive watershed-based approach is missing from this current process. The maps on the county website for the rural element show each area in isolation. The public and the council need to review landmarks and density overlays in relationship to watersheds, critical areas, and special protection zones and districts. I request that map overlays showing this information be created and released publicly before the rural element update proceeds any further, and that council reconsider its proposal based on an updated, science-based understanding of how development impacts ecosystem processes. That is, after all, the purpose and intent of the update process. Thank you.
I've reviewed the latest draft of the ordinance on the rural element, and I'm flabbergasted that this council has once again chosen
Excuse me, Sue, could you pull that mic right down to you? Thank you.
This council has once again chosen to ignore the provisions of the GMA. Not only has the language been twisted beyond recognition, but requirements and criteria have been stricken where they do not further the personal or professional agendas of certain council members, special interest groups, or the development community. One of the reasons I moved to Bellingham was the ability to live in a small city and be able to enjoy the rural character of the county only minutes away. In just the 5 years that I have lived here, I've seen tremendous growth in the county, resulting in the loss of open space and habitat for local and migrating animal species and additional pollution to our streams, rivers, lakes, and Puget Sound. This is largely the result of piecemeal planning done to placate landowners and developers who are unable to cash out during the property boom and are unwilling to accept that zoning is not permanent. They also refuse to accept that landowners are not guaranteed a return on their investments. As I've said several times before this council, speculation does not guarantee a profit. The criteria for landmarks are very troubling, as is the removal of the distance between them. As currently written, the ordinance will create one solid stretch of development on the guide meridian from Bellingham to Linden. This is exactly what the GMA is meant to prevent. The same situation exists along I-5. If given its way, this council will make one long shopping center from Mount Vernon to the Canadian border. Having grown up in New Jersey and having lived in Houston and LA, I've seen firsthand how unrestrained sprawl has ruined some of the most beautiful natural areas in the country. It would be a tragedy to see that happen here. To say that 1 house per acre, or even one house per 2 acres is rural density is disingenuous. That's suburban density at best. Rural has always meant acreage, farms, and resource lands. It does not mean expensive residential enclaves for those who are tired of living the urban lifestyle. I'm sure the original settlers of Whatcom County would be shocked and horrified to see what is happening now for the sake of profit-taking. There's plenty of room for growth in the existing urban areas and for even more in the oversized UGAs. There's absolutely no justification for expanding that growth into the rural areas of the county. I urge you to do what you were elected to do, follow the laws, and protect the spectacular beauty that is Whatcom County from more degradation.
I was struck by a seemingly unrelated news story that I heard today, and the essence of it was that unemployment in our county rose to 9.6% in the most recently reported figures. Our median income in this county is about 20% below that which exists in the state of Washington. So I bring these data up because the decisions that you all are working on revising this rural element, they will have a significant and a meaningful impact on the consequences for creating and maintaining jobs in this community. And what this is all about, staff, Mr. Davis did a wonderful job of outlining the history and what the basis for all these deliberations is, and that's the Washington State's Growth Management Act, also referred to as RCW 3670A. Now notice I said Growth Management Act. It's not the Growth Control Act, it's the Growth Management Act, and we're supposed to use common sense and balance in administrating this, and that's what I would urge council to continue to work towards. And I believe, having attended a number of your meetings, that that this has been indeed happening. In Section 20 of the Growth Management Act, the Act sets forth 14 goals of the Growth Management Act, and in a perfect world, the various goals are supposed to be balanced. No one goal is supposed to dominate the way our government goes about conducting these processes and regulations that are designed to carry them out. So among the specific goals are such things as protecting the environment.
30 seconds,
and
please.
Reducing sprawl. Also among the growth management goals are protecting property rights of landowners and encouraging economic development. So in conclusion, I know time is short. I would like to thank the 6 of you who have chosen to participate in all these work sessions recently, and for the work that you and with the assistance of our county staff has come up with so far. And I know you're not done, but I know you've worked very hard in an effort to bring about some balance to how we do things here.
I'd like to go on record before I even start by saying I think I'm of the opinion that it should be harder to develop than it is to protect the environment, and it's been my sense that it's the other way around. I moved here in 2003, and shortly after I did, a neighbor explained to me the Growth Management Act for the state of Washington, and I was so impressed. I still am impressed. I think it's a very high-minded law. It's very enlightened. It speaks to the mother and grandmother in me who always trained her kids to think ahead and be planful and semper preparato and delay gratification and think about where you want to go and how you want to get there. And so I just think it's a wise document. And I've lived in many states and in other countries, and never before, ever in my life, have I come to a place where such a document inspires us to be that mature and to use such good judgment in deciding what we want to do with our community. Towards that end, I very much admired the planning department's product that was signed by Mr. Kremen in December of 2009. And since then, I've been given 2 opportunities to tell you what I think of the work that you're doing now. One of them was a survey that we all got maybe about a year ago that I filled out, and it turns out that 69% of us told you once again that we really like infill, we really want our rural areas preserved, we especially enjoy the pristine beauty of this area, which everybody who lives in Bellingham will tell you it's one of its finest characteristics. And tonight I get to tell you once again, so I will tell you again, that I really very much value the preservation of our lands rather than the development of them. So if you're going to, the default position I hope is that. I'm concerned that it's not going to be, but that's my opinion. Thank you.
I am reminded once again by this that I'm more stupid than I would like to be. I cannot receive a document dump of this magnitude and even begin to absorb it or understand it. So I've given up on trying to understand 100% of it for tonight, and I just took 2% and looked critically at that in terms of common sense and some quantitative metrics. So I took Governor's Point, which I spell without the E at the end. I think that's pretty effete to put an E at the end, sort of like latte. So anyway, Governor's Point, I found that in 7 ways it actually is contradicting the stated aims of our general comprehensive plan. And let me list those. And a smarter person than me could probably find more, but like I said, I'm stupid. Number 1, does this serve the housing needs of Whatcom County's working population? Only our millionaire population. These are going to be several $1 million per unit, and that's just extrapolating from other chuck-a-nut costs that we have on record. And that's only for a handful of wealthy incomers seeking exclusive gated refuges, and they will have no particular tie to our community or to the workplaces in Whatcom County. Number 2, does Governor's Point have an assured water supply? Just the opposite. It is one of the few places that is assured not to have a water supply, which is quite a distinction actually. And it's even considering reverse osmosis, which is a obscenely energy-intensive way of desalinating seawater. I would expect it of an Arab oil sheikh, where they do indoor refrigerated ski areas and the like, but it doesn't sound like Whatcom County to me. Number 3, is the development site near a well-functioning major arterial road? No, it is not. Chuck-a-Nut Drive, State Road 11, is already a dysfunctional curiosity rather than a functioning arterial. Is anything going to change in the near future that would affect this? Yes, we're going to have 30 trains a day, 1 to 2 miles long, carrying coal. That's 5 hours a day where there'll be no emergency response capability to putting new residences on the far side of those tracks. I'm all for that coal project. It's going to provide union wage jobs. It's going to be a tremendous economic benefit, like Mr. Dow referred to. But don't put houses on the wrong side of the tracks.
Thank you.
And I feel like I am the general public here tonight. I have no special credentials. I am not representing anybody who has a stake in this. I am not a lawyer. I'm not a professor. I can read maps. However, as a member of the public and trying to represent the public tonight, I'd like to address the public participation portion of the zoning, the ordinance amending Whatcom County zoning code that got dumped out to me on Monday evening. And it was kind of interesting how I even found out about this. I actually got an email from Abe, my husband, who discovered about this hearing from a blog. We only had 2 days notification. This is a change. In 2009, you can read that the general public were notified of pertinent hearings or open work sessions of the planning committee through the public media outlets after a press release was sent out. And that press release was sent out up to 10 days before the event, and the number of people were actually recorded. I noticed that for the year 2010, there were just dates given where the public had a chance to speak, and there was no record of how many people attended. Currently, if I want to be well informed, I have to give I have to get online to the website, to the Planning Development Service, and under Rural Element Amendments, click under Get Involved or phone or email Gary Davis. It's a process that the public isn't going to do. And I'm concerned it's going to minimalize just the regular person who lives in town for a good reason and wants to keep the rural. My other request is to have a glossary, because one term that came up in the account was innovative zoning. I'd like to know what innovative zoning means. Thank you.
1. Rural zoning should be adopted that requires no greater than 1 residential unit per 5 acres to protect rural character as defined in the GMA. 2. There are problems with the logical outer boundaries of many of the proposed landmarks. Specifically, the Kendall landmark is overlarge and should be reduced in size to exclude extensive areas of undeveloped land and should be tailored to the existing, more intensively built environment. 3. Please amend the language in Policy 2HH1A2 to include UGAs which undergo periodic review and reassessment of their designation as a UGA, as indicated by language that I provided earlier. 4. The goals and policies in the draft comprehensive plan amendment need to be refined to protect the desirable character of Whatcom County we all support. For example, the rural comprehensive plan designation should either have criteria for designating the various rural densities or different designations to guide the locations of these zones. 5. The description of rural character and lifestyle on page 6 and of rural designation on page 9 need more substance, and the goals and policies should be amplified. Those descriptions leave out the forested land, meadows, fields, views, rivers, and creeks, and all the rest of the natural, undeveloped wilderness beauty, and do not provide an accurate description of rural in the Foothills subarea and in the South Fork subarea. Tourism and recreation, such as hiking, horse riding, and cross-country skiing, as well as open space use, should be specifically referenced as components of rural character and lifestyle and land uses. 7. The cumulative impact of permitted uses should be considered, otherwise we will defeat the purpose of rural character and element protections. 8. On page 29 of the Comp Plan Amendments, Chapter 10, Design, the section on gateways and corridors should list and describe the Mount Baker Highway, which, as we all know, is not only the corridor to the Mount Baker ski area, but also to world-class hiking, climbing, long-distance and mountain biking, and draws a huge portion of the county's tourism dollars. As a corridor, the Mount Baker Highway is critical to Whatcom County's identity and economics and may well qualify for scenic highway designation. I was surprised that it was left out of that language.
30 seconds, please.
Thank you. Last, 9. I urge you to implement in its full entirety the citizen participation and coordination provisions of the January 2005 Whatcom County Comprehensive Plan, Appendix C, Visioning Value Statements.
Time.
Thank you for your attention.
And I'm here not only for my selfish self, but for my neighbors too, tonight. And I shouldn't have said selfish, but today I just happened to get my taxes in the mail. And on my tax statement from the guide, for the Guide Meridian, I'm sure all my neighbors got the same one. It said I got a $2,500 plus bill for general commercial zone property. I've been paying those taxes for 20 years. Now, as I read this thing, there's a taking away here. Now, how can you recognize a person as general commercial and all say, no, we want to change it, take it away? No, that's wrong. The consideration, now the state considered it as general commercial. They bought a portion of my property as general commercial property. Now, the Guide Meridian is curbed and guttered and set up as a street all the way from Horton Road through Laurel. And on my property, they've set up a catch basin, a big catch basin to take all the storm water, 2 fire hydrants, water, and all is set up for general commercial property. Now all of a sudden we're going to change it. But who benefits in the change? Do I? Do my neighbors? No. It's a taking away. There's an element in this area that would like to limit anybody coming here. We don't want anybody to come here. No, we don't want. Who's we? I'd like to ask you, who's we? I served in the service, and I served with men all over the United States of America. What right do we have to say they can't come here? I'm here. I'm talking against this rezone because I hear the state mandates, the state law. No, it's still a taking away of my right. That's all I got to say.